Hi, everyone. So we are going to continue with the second session of the day, which is about the rule of law dimension across EU policies. I'm Anna Christian, and I'd like to thank you, Linda and Margot, very much for inviting me and for having me. I'm very happy to be here. This is my first London-Leiden meeting, but I look forward to very many more in the future. I was told that I have to be strict regarding the timing. So each speaker of the panel will have 8 minutes. To give the presentations. We will have 5 speakers. The first one will be Dr. Joel Grogan from King's College London and CEU Budapest. Then we will carry on with Ashley Winton, who's a partner at Winscron Derea LLP. Sorry for my pronunciation. We will also have an online intervention by Professor Roman Petrov, who has a Jean Monnet Chair in EU Law at the National University of Kiev Academy, and he's also a research fellow, British Academy. Then we will carry on with Dr. Jean-Pierre Gauci, who is based here in Bickle. And last but not least, we will hear from Ola Ugwu from the Bingham Center for the Rule of Law, and also based in Bickle. Joelle, the floor is yours.
Thank you. I have been scared and intimidated by the chairs into speaking as swiftly as I possibly can. So we're going to take a wild and very, very swift trip through the rule of law challenges that are facing Europe and the United Kingdom, with a specific focus on crisis and emergency, I say dramatically. I have started a timer, so I'm looking at you, Linda, and I'm going to be under 8 minutes. So thank you so much to the chair and Bingham for welcoming me here. What I would say is something that I don't need to this room and to everyone listening. The rule of law is important. I don't need to advocate why it's important. We've heard fantastic speeches this morning about the principles which should guide it and should guide governments in any kind of compliance with the rule of law. So I feel that I don't need to spend too much time here. And instead, I can say, in echo of this morning, it is in long-term global decline. We have mentioned a few of the major international organizations that have highlighted this in the context of the Council of Europe, the Venice Commission, the international courts. But even if we look at NGOs from the VDEM to Freedom House to also the World Justice Project, they all say the same thing, which is that globally, rule of law compliance is, well, in decline. I know that the Freedom House have tracked a 17-year decline. VDEM reports that 46% of the population in 2012 were identified as living in an autocracy, but this has risen to 72% in 2022, where 5% were only living in autocratizing countries in 2012. This is now 43%. Even as we look in Europe in this final map, we do see that there are some countries that still track a positive attitude or positive improvement in the context of the rule of law. But again, as evidenced by Hungary, by Poland, by the other states that are mapping onto the roadmap of democratic deconsolidation and rule of law decline, this is not a trend throughout Europe. I'd also highlight and echo one of the questions that we heard in the context of the UK and raise some flags as to the Illegal Migration Act, the statutory instrument that's going in to change the Public Order Act, and many of the other attitudes and principles that the current government are using in the context of the rule of law in the UK to say that no one is immune. But where does that leave us? Well, my own expertise is actually in crisis and emergency. It's governance during crisis, governance during emergency, trying to assure and, well, protect fundamental values in that context. So a few observations that we can make. I'm focusing on the aftermath of the pandemic, but we can say that it is broadly in almost any emergency that we've observed, is that crisis can accelerate trends towards rule of law backsliding, but it does not cause them. Experiencing a pandemic emergency, experience a migration crisis, I haven't had enough coffee, does not cause democratic decline, but it accelerates pre-existing trends. Second element, and this is something that has been echoed repeatedly through the COVID-19 inquiry hearings that have been going on for the last 2 weeks here in the UK, which is that crisis and emergency is not a question of if, it is a question of when. Crisis and emergency are certain to happen. Even if we look at the last 10 years in Europe, we see the financial crisis, the migration crisis, and we saw the pandemic. For those of us who also live in the UK and have crossed through borders recently, we also the Brexit crisis, but that's a slightly different beast. We can say very dramatically that we live in an age of emergency, especially in the context of climate crisis. We can see future concerns as regards food and energy security, migration, and I know that we're going to be hearing about AI next, and that's certainly been exercising the media over the course of the last few months. So what does this mean for the rule of law? Well, this creates two fundamental challenges to the rule of law that I'm going to argue are, first, the law problem. This is something that the Bingham Center are doing as part of their inquiry into emergency powers. And this is something that the COVID-19 inquiry in the UK and also the Scottish variant, along with a great multitude of parliamentary inquiries throughout Europe, are facing, which is the question of how do we reform law to take account of emergency? The law problem goes to the central tension in an emergency, which is giving governments the power to act swiftly, to act with mandate, to act to mitigate risks where at all possible, but also not to abuse those powers. That the rule of law promises legal certainty, but how can we have legal certainty if we don't know what the emergency is? How can we give the requisite tools when we don't know what they should be? How do we design law for future emergencies? One of the problems that we faced and observed in the pandemic crisis is that all of the previous existing law, the Public Health Act here in the UK, but also if we look at the emergency acts throughout Europe, they were designed with previous pandemics in mind. Generals always fight the last battle. We design for what has happened, not what could happen. But let's imagine a wonderful scenario in which we do solve the law problem. We design the perfect system. We design an excellent way that balances all of the needs of the rule of law in any kind of crisis or emergency. Well, we're then faced with what I would call the rule problem. I know, you see how I balance that there? I'm quite smart sometimes. The rule problem, thank you for laughing. The rule problem is identifying and going back to what I first said, which is that rule of law is in decline. It's not in decline in the way that we might see a sudden coup. And I'm very aware of talking about that with what is going on in Russia right now and everyone on Twitter rather than listening. But the rule problem is essentially identifying that modern autocrats engage and use and abuse law to change constitutional norms, to undermine institutions, and to capitalize on emergency to create law in their image, to create what they want. Even if we design the perfect legal system for a future emergency, which upholds fundamental values and principles, we are still faced with bad rulers. Even if we don't go to the extreme of the autocrats or the would-be autocrats, what is faced with the ordinary political decision maker is the need to respond immediately. And even without bad will, even without the intention to abuse or to combine powers, but simply facing a lack of, well, what is the alternative? A lack of awareness, a lack of commitment, a lack of ability to comprehend what the rule of law could require in an emergency, because such greater forces seem to be at play. So these are our two problems. Now, I'd hate to leave you in the last 1 minute and 9 seconds without any proposed solutions. So here's what I'm going to talk about. First, one of the most straightforward ways in which we can think about inculcating rule of law into any future emergency preparation and resilience and ultimately response is pretty basic. Inculcate a culture of rule of law throughout society. This is the expectation that political decision makers will act with democratic principles, will act with rule of law principles. Essentially, make it expected, bring it into the youth, throw forward, make it part of the ordinary culture. This is something that is different than merely the expectation that because we're great in the UK, we're always going to be rule of law compliant, but instead inculcating the expectation through education and challenging it when you see that it's wrong. I'm throwing forward to migration and AI. See, this is why I was first. The second is to instrumentalize the rule of law, that when we are training political decision makers to respond to emergencies, rather than having checklists or plans or things that will be thrown out in the face of an unforeseen emergency, we instead instrumentalize it and say, this is why the rule of law is important in an emergency. Legal certainty and regulations mean that there is higher compliance. Understanding that communities are affected very differently by regulations, especially vulnerable communities in the context of an emergency through equality before the law and non-discrimination, can enable governments to better respond to emergencies. So ultimately, even when we see the trends towards democratic decline and deconsolidation, when we are thinking about emergencies, we must think about them in terms of the best principles, because these do correlate with the best responses, the best recoveries, and ultimately the best resilience towards emergencies. I've taken an extra 39 seconds. I will apologize to the chair.
Thank you very much for respecting the time that's here. And then we're going to move straight ahead to Ashley.
This is very strict timing. Welcome. I'm Ashley Whitten. I'm a practitioner, partner in the law firm of Mishcon Guerrero. First, an apology. I'm a former computer designer and a data protection lawyer. Not a happy combination. I would like to talk to you about AI. And it's very easy to spot these headlines for ChatGPT. It's in the headlines all the time. It writes poetry, creates brilliant works of art, does your homework, and if you're a lecturer, actually marks your students' scripts. So that's excellent news. But the bit of AI that interests me is actually is not this art and script writing. It's actually decision making in two forms, either by a public body when considering the rights of individual, or by a court or other form for dispute resolution when resolving disputes between private bodies or individuals. Now, actually, I'll come to later, in the European Parliament's version of the AI Act just published, there's another reference to the rule of law, which I'll mention later on if I get to it in 8 minutes. Now, by AI here, I think we mean systems that provide results that are not merely mechanistic from the inputs. And we see this if we put in phrases into Midjourney and get fantastical art, but it also applies to systems which produce results that we couldn't entirely predict, or which result from machine learning, where the machine learns what the result might be. Let's give some real life examples. During COVID, no examinations for students in the UK. And so we had the algorithm run by Ofquat to determine the results for students. It was challenged, and there's a very useful Freedom of Information Act request and appeal, which reveals that the government was using the output of that algorithm to determine students' results. There's two not-for-profits, Algorithm Watch and the Public Law Project. I would commend them both. And they have a catalogue of similar public systems which are deciding things for us in real life. And there's 42 on the list so far, including that exam one. And they do things like helping with immigration cases and so on and so forth. One of particular interest to me is called the Bridges case. This is where the South West Wales Police use AI to do live facial recognition on you in the street or at a football match or outside a football match to find out who you are as you're walking along the street. And this has been through the courts. And so we have the police were found not to have acted fairly. And so we now have some good intelligence of how that system works. I can tell you, I've analyzed it for clients in other applications. It is quite sophisticated. And perhaps it's already being used in more places than you might think. For decision making, well, you know that if you don't file your tax return, you get a £100 fine. Well, a computer does that. And Mr. Card of Khan Properties objected to his £100 fine. And he pointed out, well, hang on a second, in social security law, there is a bit of law that says that the government may make decisions by computer. There is no such equivalent in the taxes legislation. So he doesn't want to pay his £100. Well, unfortunately, in that good case, Khan Properties HMRC, there's a nice discussion of the matter, not entirely settled on that point, but that would be my starting point if I was to research that as part of my essay. If you have a domain name dispute, there's a thing called the UDRP for resolving those. And some very good Australian academics, Messrs. Viken, Levy, Christie, and Baldwin, have calculated that an AI system can resolve those domain name problems better than the historical human solutions we've got today. So that could be an indicator of things to come. And indeed, there's already good examples of big databases being formed around the world of court judgments for AI to be applied to. In particular, 2.6 million cases being ingested in a system in China to allocate criminal penalties to individuals who may have broken the law. Before we get excited about the future law, let me just quickly remind you of the current law in the UK. There's 3 heads to it: Data Protection Act, Human Rights and Privacy, Equality Act. Data protection, as we know, our protection is in Article 22. A data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces, here's the test, a legal effect concerning him or her, or which similarly affects him or her. There's some exceptions. Is it for a contract required by law or consent? But in the first and latter, consent and contract, you need to have a route for a human review, but not so if it's authorized by law. So, data protection law, human scope of it for your decision making, gives you no protection if the decision making has been authorized by law. So perhaps no protection at all. Human rights and privacy, I'm sorry to say, my world probably knew, or the data protection world knew very little about privacy until some recent cases. It is, of course, an entirely separate body of law, and very important in that Bridges case I mentioned before, as well as the Schrems international transfer cases, and clearly an important part of that live facial recognition. But I want to mention this because, of course, as we know, Article 6 gives us that right to a fair trial. So if computers are deciding things for us, are we getting a fair trial? Now, others here may have a better idea of where the law is going, but as far as I can tell, nothing useful has been decided yet. And the prevailing direction seems to be the court saying, well, as long as there's a right of appeal to presumably a human, we don't mind that automated decision-making at that first step. And that is perhaps a concern. The Bill of Rights bill, Mr. Raab's bill, affects both these Articles 6 and 8, but I'm hoping that that has been withdrawn. Equality Act has a whole bunch of protected characteristics, and which ensure non-discrimination, but I will mention, because I'm short of time, that it's interesting to note that the crossover between that and data protection law is incomplete. We have sensitive personal data protection and a broader set of characteristics under that Equality Act. So the future, in my last minute and a half. So we've got this AI Act proposed in 2021. We've now got the Parliament's draft just published. It's going to go into trialogue. It gives a hugely broad definition of AI. Everything is really AI under that Act. In the Parliament draft, actually, it stripped away the schedule that gave some examples and made it even broader. And the Parliament wants to introduce some general principles of human agency and oversight, privacy, governance, transparency, and so forth. When you're in the Act, you get classification. Is it for unacceptable risk, high risk, limited risk? For unacceptable risk, that Bridges case, so actually now the Parliament says no live facial recognition publicly of their examples there. In the high risk category, we have the thing that concerns us, which is administration of justice and democratic process. AI systems intended to assist a judicial authority in researching and interpreting facts and law will be high risk. Now, the Parliament goes further, and they say that the use of artificial, you have to help me with this sentence, so please pay attention. It says here, the use of artificial intelligence tools can support, but should not replace, the decision-making power of judges or judicial independence. As the final decision-making must remain a human-driven activity and decision. The problem I have is I'm not sure whether final means final at every stage, or final just means the Supreme Court. Because if the latter, we could have computers deciding our cases until we get to an impossibly expensive legal process that no one really has fair access to. So that, I think, needs to be cleared up as the budget goes through trial. Well, I'm going to leave you in my last half second with the UK, and that's all I need. We have no draft law. We have a pro-innovation approach, which means no law. There's some pretty pictures which I could show you, which show there's some sort of central risk function to catalogue the lack of law. But we do have, if you're interested, this Digital Regulation Cooperation Forum, CMA, FCA, ICO, and Ofcom. And actually, they are perhaps leading the charge in sensible things to read and understand in relation to AI and algorithmic processing generally. And that's why I would lead you to. And so let me conclude. Well, look, maybe I've been unfair on the UK. The consultation is only just closed. They're still at this early stage. No one really contemplated Chat GPT or similar. And clearly the UK wants to form alliances with the US, presumably. And so maybe we will see some primary legislation in this space shortly. Thank you, Anna, for the extra minute. You're kind.
Well done. Thank you very much. We are going to move on to Professor Roman Petrus' online intervention, which is going to be about the rule of law in EU external relations.
Good day. I hope you can hear me well. I really apologize for not being with you in London. Yesterday there was a wonderful event at the Leiden Law School on Ukraine, so I just didn't make it in time. Nevertheless, the topic, what I'm going to talk is pretty broad, and it's very difficult to squeeze it in 8-10 minutes, but I'll do my best. The European Union is a known and global promoter of rule of law, not only domestically, but externally. Of course, we all keep in mind Article 2 and Article 21 on the Treaty on the European Union, which explicitly says that the task and objective of the European Union is to promote its common values, including rule of law externally. And it's a backbone of the EU external policies. In general, the European Union completes this objective by 3 means: via EU external agreements, via EU external policies, and the enlargement process. Just in short, very briefly to remind, when we talk about the promotion of rule of law via EU external agreements, we can talk about big variety of agreements with different legal bases. The most known of them are trade and development agreements, partnership and cooperation agreements, like just recent one with New Zealand or Kazakhstan or Armenia, as well as most known association agreements, which probably the most used tool of the EU external policies. Almost in all of these agreements, preamble and leading entry articles on aims and objectives of the agreements emphasize that European common values, international principles of international law, and to be highlighted, rule of law constitute an essential element of these agreements, and therefore cannot, in case if any party, of course mainly third party, violates, the entire agreement could be terminated. And it makes a very strong legal tool of influence on a party of the agreement actually to take this article seriously. When we talk about EU external policies, of course, the European Union has been hailed as a lab for EU external policies, especially around its neighborhood. It's important to recall European neighborhood policy, Union for the Mediterranean, Eastern Partnership. In all these policies, rule of law and sharing common values, which in fact are European common values to be shared by third countries, constitute a very important and central role, and define the approach which is called the conditionality policy. So it means the European Union provides assistance, technical, financial, and other sort of assistance, including allowing gradual integration to the internal market, conditional on democratic reforms, in particular, rule of law and sharing common values with the EU. And of course, last but not least, the accession enlargement policy. It's, of course, is known for its 3 Copenhagen criteria, among which criteria number 1 exactly, criteria called democratic values and rule of law, which explicitly requires candidate countries, future EU member states, to show evident result in sharing and fulfilling, complying with this criteria, to show specific results in introducing rule of law in this country. In this regard, when we talk about the enlargement, of course I cannot bypass my own home country. We just recently, last year, was recognized as a candidate country status. It happened very shortly after the invasion, of the Russian invasion. Frankly speaking, and I said it yesterday in Leiden, that I was raised and I was already had no hope to see my country to get any even perspective of the membership. And everything changed all of a sudden in terms of few weeks. And it must be acknowledged that in this respect, especially in respect to Ukraine, granting the candidate country status was and must be considered as a part of a moral political support in order for Ukraine, in order to enhance its ability to resist and its resilience. Nevertheless, now Ukraine is determined to push forward, and it's going to be the very first case in the EU history when a country which is openly at war with the Russian Federation, which is going to endeavor to fulfill several multitasks: to win the war, to survive, to recover, and to acquire the EU membership, especially to go through meticulous and highly technically complicated negotiation process, which seems like impossible task. Nevertheless, the Ukrainian government is committed. Of course, reservations remains, and the EU approach in this respect, which was underlined at a recent EU-Ukraine summit early this year, was, well, just as it was read from the EU side, we do not take seriously your calls, it means Ukrainian calls for so-called speedy enlargement regime. We rather will follow traditional enlargement procedure, and we expect Ukraine to fully comply with the Copenhagen criteria regardless the war effort, and therefore policies must be followed this way. Right now, and just recently, there was an OLA report coming from the Commission on the readiness to open negotiations for Ukraine. And it was stated that Ukraine only managed to fulfill 2 out of 11 criteria. Most of these criteria relate to rule of law, independence of judiciary, fighting corruption, and also freedom of media. So it shows a very important and very challenging task for Ukraine to fulfill. Nevertheless, we'll stay optimistic. And the last point to finish with my intervention, of course, it was rightly mentioned, we're all now on Twitter and YouTube or whatever your social network you use, possibly Trump one, I don't know. But I would like to finish with my own remarks about with reference what's going on in Russia right now. Very briefly, it must be noted that Ukraine and Russia concluded almost simultaneously partnership and cooperation agreement with, at that time, European communities. Agreements were almost identical. So Russia even was more ambitious, and the European Court of Justice even touched upon enhancing the power of this agreement. In case of Ukraine, and just this year, we celebrate 30 years of this agreement, and Professor Lazovsky, who is in audience, is going to publish a volume on this devoted to this event. In case of Ukraine, this agreement played a crucial role for raising the whole generation of young experts and devotees to rule of law and democracy in Ukraine, who actually contributed most to both revolutions of dignity and fighting the aggression. And in case of Russia, it didn't happen for some reason. It puts very serious questions how rule of law should be promoted. Is it just a black letter policy employed by the EU, or something else should be done? How it happens that Ukrainian past became so different and more successful? But what we are witnessing now today, this coup or mutiny, whatever, going on in Russia, actually initiated by this cruel, horrible mercenary group. And I read the latest statement issued an hour ago by this Mr. Prigozhin. It's about rule of law. He basically states in his, in response to Putin's address, he says, we want to fight because we want to combat and eliminate corruption, bureaucracy, and total lie in our society. So we are witnessing a very interesting situation when both sides consider rule of law differently. The Russian president in his address says that basically rule of law must serve him as a person, as the leader of the country. And this Wagner mercenary group, they say, we want to fight for rule of law, which must manage the country. Certainly we are living, especially today, through historical time, and let's follow this action type events, and thank you for your attention.
Thank you very much for your very interesting and timely comments. We are going to move on to Jean-Pierre.
Yeah.
And we're going to hear about the case of migration.
Thank you very much. And thank you very much to you, Linda, and Margot, for the invitation to be here today. I'm going to be slightly less optimistic than some of the other speakers today. I think in the context of migration, in the context of forced migration in particular, we are seeing both the UK and the EU completely sidestepping the rule of law. I was going to use the term backsliding. I think it's much more than that. It's much more urgent than that in the context of migration and forced migration management in particular. And I'll start with something that was mentioned earlier around public discourse and where that is coming from when we talk about migration and the kind of negativity of that public discourse around migration and the impact of that discourse on how we respond to migration. And I think unlike various other areas, in the context of migration, a lot of that negative discourse starts from politicians. It starts from home secretaries, it starts from ministers of internal affairs, etc. I live in the UK. We've all heard the speeches over the last few months. I come from Malta. We've all heard the speeches over the last 20 years. And I think a lot of what Malta does, to take the example of Malta, a lot of what Malta does in the Maltese context, a lot of what Malta does on the European level is about the interplay between the national and the European level. It is about making that message, passing the message to the European level that Malta cannot deal with migration, which message is not received at the European level, but is very much received and internalized in the Maltese context, which means that the local population in voting, etc., is taking that message to heart when it comes to voting. The second kind of generic point I wanted to mention is the terminology of crisis. It was mentioned earlier when we were talking about COVID, when we're talking about various other crises facing Europe. Migration is very often put into the same category. I'm not saying there isn't a crisis in the context of migration, but I am saying that it is a very different crisis depending on how you present that crisis and who is presenting that crisis. The crisis that we see as perceived by migrants' rights activists is a very different type of crisis than the crisis that is portrayed by EU officials, by national officials and national politicians. So when it comes to the rule of law in the EU and the UK, when it comes to migration, I think we have a very kind of clear picture of where the issues lie. In the EU context, we're seeing a shifting of Europe's border. We have seen a shifting of Europe's border over the past 20 or 30 years through things like privatization of immigration control, carrier sanctions, further border controls, etc. What we've seen in the last 15 years is the further shifting of responsibility onto countries like Turkey and countries like Libya. Now, if we take the example of Libya, for example, we're seeing EU member states and EU organizations involved in supporting, that's a very nice way of putting it, the Libyan authorities in so-called search and rescue in the Mediterranean. Most of that is not actually search and rescue. Most of that is interception at sea. Most of that is being done as a way for Europe and European Union member states to not be held accountable for human rights violations that would ensue if they were to rescue or intercept people and return them to Libya in the first place, as was done in the context of the situation that led to the Hirsi Jamaa judgment by the European Court of Human Rights. When that judgment comes through, we see the European Union member states shifting their efforts. Instead of picking people up and taking them to Libya, they pay the Libyan authorities to go out and so-called rescue and take people back. The violations are the same. The treatment people are receiving in Libya remain the same, if not getting worse in the last 10 years. But what we're seeing is a shift away from a context where the European Court of Human Rights and other contexts of accountability can actually participate in the process, or rather when those processes can actually be addressed. This is even worse when there is an awareness of the situation in Libya, and we see that awareness in other areas of foreign policy, and also when we continue to see the number of deaths at sea, as the boats off the coast of Greece shows recently. But that is one example of many examples of people being lost at sea. If we think about accountability as foundational to the rule of law, we also see this in the context of international players. So if we look at the interactive dialogue with the fact-finding mission on Libya, for example, we see the European Union going there and saying, oh yes, it's great that this happened. We do see that there are concerns in Libya. We acknowledge that there are concerns in Libya, but there's no accountability for us as a European Union or our member states for what is happening there. Completely cutting off that line of accountability in that particular context. Relationships with third states, Libya is one example. There are others where we see these issues. I think Libya is probably the most stark example, but we see this in the context of the EU-Turkey statement. We see this in the context of relationships and abuse of aid agreements with third countries. So for example, the situation with Niger and the immigration control conditionality that is being implemented there. And again, what accountability measures exist there. On the plus side, because there is so much happening, and because the channels of accountability in the traditional sense are largely closed, we are seeing significant efforts by a variety of lawyers, organizations, NGOs, and others trying to find different channels for accountability. So using, for example, EU financial regulation channels or regulation of EU finances and how they're used as a way to hold the EU and its member states accountable for what happens. Shifting very quickly to the UK, the illegal immigration bill has already been mentioned. There's one thing to be said for the bill. It doesn't try to hide what it's trying to do, right? It basically says upfront, this bill is not in line with the European Convention of Human Rights. It's not. I mean, that is probably the only accurate part of the bill, right? The provisions of the bill will not meet the objectives that the bill tries to set out for itself, but obviously does meet other objectives that are set for the bill elsewhere at the more kind of political rather than legal level. We can talk about violations that the bill will mean for international law, whether that's Article 31 of the Refugee Convention, whether that's Article 33 of the Refugee Convention, whether that's Article 3 of the European Convention of Human Rights, Article 3 of the Convention Against Torture, the International Covenant on Civil and Political Rights, as well as the Convention on the Rights of the Child, Convention Against Trafficking, the Protocol Against Trafficking, European Convention Against Trafficking, etc., etc. The bill amounts to a refugee ban, but also, and if we want to take a more restrictive view of what the rule of law is, it does remove any sense of accountability for those measures, but also access to justice for the people who are affected by those measures, even if we are talking about measures that are life and death decisions in many cases. I think one final point that I want to make is that, again, when we talk about crisis, when we talk about these sorts of measures, both those being taken at the EU level with the new agreement that the Council has recently agreed, we are talking about measures that will very, very significantly negatively impact the human rights of migrants, access to justice for migrants, and by migrants in this context, I mean forced migrants. And again, we are talking in a context where we have seen positive measures in terms of protection taking place in the context of the Ukraine conflict, for example, that have been very positive, have resulted in improved protection for people who are displaced from conflict. So it's very difficult to see how we can justify one and how we can justify the restrictive measures in one context and not the other. This isn't me saying we shouldn't be protecting Ukrainians. It's me saying, let's learn from how we protected Ukrainians to protect non-Ukrainians in this particular context. Again, the possibility of challenging these decisions, both under the illegal immigration bill and under the border procedures, which will become much more the norm if what the Council has agreed becomes the norm in the EU, will mean that judicial engagement will be reduced and access to rights will be very negatively impacted. My time had run out about a minute ago, I think, so I'll stop there.
Thank you very much, Jean-Pierre. And now we're going to move on to the last speaker of this panel. Who's Ola, and she's going to tie with Joel.
Thank you, Anna. I understand I'm the only thing standing between you and lunch, so I'll try to be brief. Just to talk a bit about myself and my interesting journey to a career in the law. I'm actually from the Niger Delta in Nigeria, and growing up as a child, and this is something I speak to students that I meet every time when I'm doing my work, I say to them, just focus on the things that you can control. You can control everything, but you can actually control, yourself and the things that you can control. Focus there, and you have a greater chance of making a bigger impact. So I grew up from the Niger Delta, looked at the devastation around me, thought, what could I do about this? Felt very helpless, but I decided to focus on my studies because I felt I can control that one. And so I graduated with a first class, secured a scholarship from American Association of University Women, and I had the privilege to study at Edinburgh University for my master's, focusing on resources management. Now, for my master's, I actually undertook a dissertation project, and that looked at sustainable development and public participation as ways to sustainably develop, any situation, any country, democracy, whatever you're doing. Public engagement is very, very critical. So my journey to public engagement has actually been a long while coming. Well, when I finished at University of Edinburgh, I had the privilege again to do my, I was offered a PhD on sustainable development, but unfortunately I didn't have the funding. So I took the next best opportunity that I had, which was being hired from university by Procter & Gamble to lead the human resources effort in West Africa. And my job involved traveling, globally, hiring people like myself who have studied, who are in the diaspora, but who would like to come back to West Africa and work. So I did that. And then I was also the Equality, Diversity and Inclusion Manager for Procter & Gamble, establishing the first ever Diversity Day, which is a trend that is ongoing now, where you celebrate culture and where people are from. I did that for a bit, and then I went on to do commercial roles, senior commercial roles in Procter & Gamble here in the UK at Weybridge, and worked across a number of other organizations, Dairy Crest, Saputo Dairy. But then during the pandemic, and it's interesting that earlier on in the section, we've all talked about legal aid and the impact of legal aid. Interestingly, there was a number of reforms in legal aid back in 2013, 2014. And the most people, in my view, that were being impacted by that reform were domestic abuse victims. So during the pandemic, it just went through the roof, the rise. So I went back to university to study the impacts of LASPO reforms on these victims and their children, and how that obviously spills out onto society. I did an interesting study, and some of my recommendations have actually been implemented by the government. I then secured a fellowship from the Human Rights Lawyers Association in order to undertake an internship here at the Bingham Center, and that's how I came to BICL. Following my internship, I then went on to work for the largest public legal education charity in the UK, Law for Life, prior to returning to the Bingham Center. So I've walked you through my exciting career to law because I think I'm going to be a better lawyer just because of the professional experiences that I've had. Sorry, go on. Yeah, thank you. So if I talk then about the Bingham Center, as most of you may know, it was established in 2010 and named to commemorate the greatest, most prestigious judge of his generation, Lord Bingham. And Lord Bingham, in defining the rule of law, said that in a world divided by differences of nationality, race, color, religion, and wealth, the rule of law is one of the greatest unifying factors, perhaps the greatest. So we have talked a bit about the rule of law this morning, but I think for me, the most important thing is when we talk about diversity and democracy, if there is one unifying principle or one thing that all of us should be focusing on, it's obviously the rule of law. But here today, I'm not here to talk anymore about the rule of law. I'm here to talk about the practicalities, how we actually instill this. As one of the speakers have spoken earlier, and how Dr. Joel, spoke earlier about inculcating this. So that's what I'm going to walk you through. So the rule of law, it's the bedrock of democracy. We all know that, and is a core value in the UK, Europe, and globally. Despite the fact that Brexit happened, which was effective January 2021, the UK continues obviously to be committed to the rule of law as a constitutional principle. Magna Carta's global influence can be underestimated, whether it's from the Universal Declaration of Human Rights or the American Declaration of Rights. All of those epic moments all reference the Magna Carta Agreement that was signed here in London in 2015. So in terms of advancing the rule of law in a democratic society, what we do and what my job is, it's focusing on teaching the children, the younger generation, all about the 8 principles that Lord Bingham eschewed and advanced in this book. And I am a very, I'm a proponent of this book. Like I just love it. I read it every day, like my Bible. So if you ever wondered what the rule of law is all about, just grab a copy. In very explicit, clear way, you know, he just expounded and explained clearly what the rule of law is. So I just wanted to say that for us here at the Bingham Center, in terms of public and youth engagement program, our vision is to utilize the Bingham Center's platform, if you like, the BYEP platform, to advance the rule of law by facilitating diverse conversations. And it's all well and good to have the reports and to have the, you know, the academia perspective on things. But until you begin to have that diverse conversation, until you begin to bridge that divide between law and practice, until you begin to involve different groups, you know, especially disadvantaged groups and groups that you normally wouldn't have or give a seat at the table, until you begin to do those things, we will struggle to inculcate the principles that we all eschew as lawyers. So how are we then achieving this at the Bingham Center? Well, we talked about embedding the rule of law earlier, inculcating it. That's precisely what we do. We embed the rule of law principles from a young age. And this we do through school assemblies, through school workshops. We go out there, and my favorite book says, train a child the way he should go, and when he's old, he will not depart from it. So we don't wait until they become parliamentarians and then start to advise them and start to review the rule of law implication of legislation. It's a bit too late then. We try now to inculcate it into their everyday lives and just teach them what they really need to know. We do these obviously through our school programs. So we have developed quite a number of materials for Key Stage 3, Key Stage 4, and this is, children from all the way 7-year-old and upwards. We do this as well through partnership with digital organizations like each other, where we produce short videos, obviously tailored to our audience, school children, and we also give them a voice. So we actually publish articles from disadvantaged groups, from children, people with lived experience that would not normally have access to publication and media. We also have developed rule of law resources for youth in Europe. So not just in the UK, we actually focus in more further afield, and obviously produce materials as well for school workshops, including Magna Carta resources, which is, the bedrock of democracy. We have also this year established a rule of law digital hub. And what this digital hub does is it houses all our materials in one place, because you can imagine the plethora of information out there. There's just a lot going on. So this is a place where you can come onto and learn everything about democracy, rights, just everything that you really want to know about the rule of law, and not just in the UK, actually across Europe. So we have developed all these materials, and this is how we try to inculcate the rule of law principles. We also obviously have our MOOC, which is a massive open online course that you can study at your own time and learn about the rule of law. We have over 45,000 views, and actually 16,000 people have completed this course and graduated. Now, most of our participants are actually from Bangladesh, from India, so very global course. The other thing that we are doing is inculcating the rule of law principles through sports. Now, it's all well and good, like I said, to hold the conferences and the seminars and to teach in school, but most of these children or young people or young adults, they actually learn outside of the classroom. So what we've done now is partnered with sports organizations sponsored by Sport England, called Sport Inspired. We engage with these students on a day of sports. So we give them opportunity to have over 10 sports, from tennis to taekwondo to, karate, things that they would normally not have in their schools. But whilst they're doing this, and through the course of the day, we're engaging with them, we're teaching them rule of law principles, and they have access to us, professionals in the field and legal industry, professionals in consultancy firms, from the legal firms, from banks, and they can ask one-to-one questions. Most of them learn better that way. They're not going to, learn as much in a classroom, but then they are with the people that can actually guide them and teach them, and they spend the whole day with us. So these are some of the things, that we do. And then how also do we achieve this? We actually provide these opportunities to what I call the future parliamentarians, to ensure that they are practicing, this rule of law principles. And we don't just teach them, we give them hands-on experience of the workshops, and then we give them an opportunity to practice in a safe environment how the rule of law should be applied to issues that they deal with. Now, one of our other initiatives is also bringing London youth face-to-face with their parliamentarians, the people that they've actually voted into power, so that they can have these honest and open conversations, not just with parliamentarians, with academia like yourself, with expert practitioners like Ashley, to ensure that they are having dialogue about issues that are impacting their lives. This was our mayor event where we looked at we delved into artificial intelligence ethics and the rule of law. And we have another one coming up in July where we look at youth justice, and then another one in September looking at homelessness. So these are issues that these young people are dealing and grappling with, and we need to have these conversations. Some of the things that we do, all of this that we've achieved, we have done it through our diverse volunteer group. So these are ambassadors, I call them ambassadors. They're BICL ambassadors in all the universities that you can, think about. And for me, this is a vision of the future. This is what our political and legal landscape should look like, because then we will begin to gain the trust of the public, because we are representing, or we represent the people that we are representing. So we look like them and they can trust us. So these are our ambassadors that I work with, and I couldn't do any of this without them. And then finally, my call to action is just to say, we need to leverage our public legal education to advance the rule of law. We need to leverage diversity, and then we need to leverage synergies, because you can see demonstrated on the 8th of July how much impact we can have when we all work together. So that's it from me. In conclusion, we aim to change and challenge the status quo, and we'll do this through approaching the advancement of the rule of law dynamically. And if we do get this right, the impacts on democracy will be huge. Thank you.
Thank you very much, all, also for sharing your inspiring journey with us.
Sorry about time.
Do we have, can we take a round of questions before we go for lunch? So even for, yes, okay. So if there are any questions or comments at this stage, we could take a couple of those before we go for lunch. Yeah.
Thank you. I just have a question about the EU and migration. So, and sorry if this is a silly question, this is not my area of expertise, but to what extent do we have a common migration policy? And is it still the case that this is very much member state competence, or has that evolved now? Do we need more harmonization to tackle some of these issues and, you know, maybe get a bit more solidarity?
So, sorry, do you want to take?
No, I was just wondering if there are other questions or comments we could take.
Yeah. So when it comes to dealing with foreign immigration and refugees, we do have a European asylum system, and it is the most advanced and the most sophisticated regional system of protection, and in a number of ways, one of which is that it doesn't only deal with substantive issues, including what are the rights of refugees and who is a refugee, but it also deals with things like how do we assign responsibility for addressing asylum issues, how do we, what are the procedural steps for seeking asylum. So we do have that. We have had that for a while, and it has continued to develop over time. And we are currently going to yet another round of, I would say updating, but that makes it sound like we're sort of progressing in some sort of linear trajectory, which we don't think is particularly the case, especially with this round of development. I think there's a number of parts of that system that work. So we do have some standards that are set up, but there are many parts of that system that do not work. It does assume that there is a level of harmonization in asylum determination. So if we take the Dublin regulation, for example, or the Dublin system basically says only one member state should be responsible for asylum. That makes perfect sense. We don't want the same kind of thing to be done with about 27 and the countries, and we do want to regulate how people are moving across the other states when they're that makes sense. However, the way the responsibility is assigned in the Dublin system is effectively on the basis of one having a relationship with a particular country, with visa, for example, country. Second, this having family members in those countries. And then the third criteria, which is supposedly the third criteria, but actually becomes the main criteria that is used, is first-time protection. That means that countries like Malta, Italy, Greece, Spain, and others do end up taking the lion's share of responsibility for asylum applications in the European countries. That isn't work. That is not solidarity. That is literally counter to solidarity. That is being addressed in some ways. So we do see in the New York agreement that there won't be a mention of the system. However, there are other mechanisms for solidarity, including in terms of financing. When it comes to, and in this particular agreement, there will be some benefits / costs to not taking responsibility for some side effects. The numbers are very limited in that particular context. But what we see is also that there are other mechanisms where you use, for example, funding or support within funding particular migration management, whether that's through whichever funds is in that particular time. However, when it comes to actual solidarity, we do see that there is still a very significant responsibility share, which is that with border states in particular. We also see a reluctance or a complete pushback against funding, against measures to improve solidarity by particular countries. And this one in the particular context of the latest negotiations, countries in Northern Europe in particular, are pushing against shared responsibility. In the past, when there were measures for mandatory verifications of very small numbers of people in the context of 2016, so for the immigration crisis, then we had challenges in front of the European courts by that following. I don't know if that answers your question. Happy to discuss.
Very much. Has there been any additional questions in the meantime? Or comments? Maybe we can take this.
Thanks so much for all of your contributions. Facing this kind of environment of backsliding, I'd really like each of the panelists' thoughts about what the most effective way is of convincing those in power that rule of law is worth it, because it is cheaper and quicker to ignore it, and it consolidates their power. And I think that's all of those reasons to ignore it are kind of been indulged by people in power. And I'd love to, it's kind of more of a kind of an impact question or a policy question than an academic one, but yeah, just off the back of the youth engagement and that strategy, I'd love people's thoughts on strategies for impact of kind of reversing the backsliding.
I'll just start. For me, I think it's simple. When you have dialogue, a lot can happen. So for me, I think it's, in terms of strategy, get these people that are being impacted by these legislations and these policies, just get them in front of the parliamentarians, the decision makers, the policy makers, and let them talk about their lived experience. Let them talk about how the legislation is impacting them. I think just, you know, having that dialogue, I think it will go a long way.
If you allow me very, very brief cynicism before lunch, I would show correlations of show them the money. There's higher correlations with GDP and rule of law compliance. Also, again, cynically within the context of what's going on today, the stability of your regime is strongly correlated with rule of law compliance.
I was about to say the exact same thing, actually, and we have had this being used, right? So we've had the City of London arguing against the legal migration bill, not so much because they care about the particularities of immigration policy, immigration law, etc., but because that sort of relationship with the rule of law does impact the city and the financial sector, and as well as everything else. So I think that is an argument that would work. Yeah, and then the kind of bigger picture is, yes, you know, train people in the rule of law, empower communities, community organizations. I think one of the things that we've seen in the last few years in the migration sector is having more migrant community organizations coming up and being the voice of migrants' rights, rather than, quite frankly, organizations that are claiming to represent having actual communities that presenting themselves or represent.
If I might leave you with an even more cynical view, I am very worried about the rule of law in its application to decision making. I mean, it is clear that decisions will be made much more cheaply and at scale with computers. The government might be just satisfied that there is some possible eventual right of appeal to a human and then just carry on. And I struggle to answer your question and to think of a good reason to fend off that outcome. Obviously, we'll be sharing a tear for the poor lawyers that lose out as well. I know that's your primary concern. But aside from that, I think it is a real risk, because the stats will show things like a high degree of accuracy, and the government will just say, oh, great, just go for it. And then we'll lose out. I'll leave you one last thing. It's not a quote from me, but it's a very interesting thing. And it might be relevant to your students as well. Another lawyer was asked if they're going to use this chat GPT thing to write judgments for courts. And they say, well, chat GPT works by giving you the best average answer. But here at Suet, Rabbit and Run, or whatever his law firm was, we're in the business of giving exceptional briefs to the court. So the chat GPT brief would never be the one that we would submit. And so that's interesting, isn't it? That the decision-making would never give you an exceptional argument that you might need in court.
And then before we go off to lunch, I'd like to ask Roman if he has any concluding comments.
Yes, to answer the may I add, to answer the last question, I would like to say, when we talk about the rule of law, as a Ukrainian, I would say that the rule of law is a major precondition for country like mine to join the European Union. And in this respect, it works really well because you are pushed to follow the reform. As a European, I would say that rule of law, if anyone is ready to defend rule of law, it means it really works. And I think it's a main feature. Thank you very much.
And thank you to all our speakers, very inspiring interventions. And I think we can carry on with the discussion over lunch.